Hi everyone, Dave Sugden of Evidence at Trial. Let's spend a few moments talking about opening statement and see if we can identify a couple tweaks that will make your next opening statement even better. And what I want to first do is talk about the conventional wisdom we so often hear and then contrast it to what the good trial lawyers actually do. In a well-known treatise, it says the opening statement should be brief, concise, and directly to the point. I agree. It is normally best to follow chronological order. I would agree most of the time. The next portion I would suggest is entirely wrong. It says, refer to your client as my client. Don't identify yourself with the client by using the term we, as in the statement, we shall prove. I don't know why the text says this. I think what they're trying to suggest is to create distance between you and the client. If you refer to your client as your client, all you're doing is reminding the jury that you're a paid lawyer. The other thing you're doing is by making that separation is you're creating a distance between the credibility you will build over the course of the trial and your client. In other words, one of the key tools of persuasion is to show that you are the credible advocate. You are the one bringing out the truth. You are the one who's being honest, and you want the goodwill that you're building up to be tied with your client. And so, again, you want to be talking about we in opening statement as much as you can. It then says, avoid telling specific facts. Always maintain a fluid position. Again, I would suggest this is wrong. And I think the advice is rooted in this idea of let's make sure that we're sort of hedging an opening statement, because if a fact that you say is going to happen and it doesn't, it may backfire. But let me suggest, if there's a fact you have to prove in order to win the case, you better identify it in opening statement. If this is a fact necessary for you to win and you can't prove it, you lose anyway. But if you do prove that fact and you haven't mentioned it in opening statement, the jury may not even realize the importance or the context of it. And then it says, avoid all types of arguments during opening. This is not the time to confuse the jury with facts that are in dispute. Everyone knows, the jury knows the reason they're in trial is because there are facts in dispute. And you have to be able to present it in a persuasive way. And the reason why is, let me suggest why this is all wrong. And that is because no one is impartial about anything for any longer than he or she has to be. In other words, even though in opening statement, the judge will say, this isn't evidence, this is a preview of the evidence, the jury are starting to decide who they believe. And you're providing a framework or a prism in which they will interpret the evidence. And so this idea of avoid identifying facts that are in dispute, you have to identify the facts that you're going to prove. The text also says avoid arguments. And the reality is in opening statement, you can't argue. It's called opening statement, and at the end, closing argument. And so how are we able to provide a statement in a persuasive way? And let me suggest a number of ways you can essentially provide a persuasive opening statement without crossing the line of making an argument. The simplest way is to say, the evidence will show. The evidence will show that my client was defrauded. If you want to sort of build in terms of levels of persuasion, the next is you tell the jury that a witness will tell you something. Next is you will hear, you will learn. Finally, I will prove to you. And in the course of an opening statement, again, not what that text says, but tie your credibility to your clients, the party that you have the privilege of representing, and you explain to the jury, I will prove to you this, I will prove to you that. And that is how you can make a persuasive opening statement at your next trial. I hope this was helpful. If it was, please download, rate, review, share, leave a comment, subscribe to our YouTube channel, and also check out Evidence at Trial, where we have a number of online courses that do a deep dive on the strategies and rules of evidence to make sure that you can use these rules of evidence as weapons in your next trial. Thanks for watching.